We're going to go ahead and get started. Thank you all for joining the Center for the Study of the Administrative States Public Policy Conference on Rethinking Due Process. My name is Naomi Rao, and I'm the founder and director of the Center. I know that many of you here are familiar with the Center and have been to some of our events, but for those joining us for the first time, I just wanted to give you a bit of history. We started with our first conference a little bit over a year ago, and since that time, we've held 5 of these public policy conferences, 4 research roundtables, and have commissioned about 25 academic papers. And these efforts have really sought to spur debate about the political and constitutional accountability of the administrative state. We've done this by inviting scholars, practitioners, judges, government officials, and public policy experts who represent truly a wide range of perspectives to discuss and to propose solutions to pressing problems of administrative law. Today's conference on due process presents a big topic which extends across many subjects and many contexts. And the core of this conference is 5 papers that were presented at a research roundtable a few months ago, and the drafts of those papers are on the website if you're interested in taking a look. And this conference really seeks to apply the insights of those papers to broader public policy debates. We're going to begin this morning with a panel on foundational matters, looking at what exactly due process means in the Constitution and why it matters. The second panel will focus on what due process might be required in administrative agencies, and the third panel will consider due process problems in the context of agency adjudication. At our luncheon keynote, Judge Doug Ginsburg and Professor Philip Hamburger will discuss the administrative evasion of procedural rights. I'd like to thank those who wrote papers for this conference and all of our speakers. I'd also like to say a special thanks to Dean Henry Butler, who was unable to be here, but who has provided very substantial support for the Center and its projects. And I'd also like to thank Jonathan Adler, who's helped me organize this whole due process project. And I have to say the Center's work has been much easier since we were joined by Leah Verbitsky, who's our event specialist. And she keeps everything running smoothly and handles all of the details, and it's really a pleasure to have her. So thank you very much for being here. I hope you enjoy the conference. So now I'm going to change hats. I'm going to be moderating this panel. We have 4 distinguished academics with okay. We have 4 distinguished academics here with us today, and all of their biographical information can be found in the booklet, so I won't go through that. We're going to go in the order of Gary Lawson, Ron Cass, and Woolhander, and then Nelson Lund. Both Gary and Ron wrote papers for this conference, and as I said, you can find those on the website. So we're going to begin then with Professor Lawson.
Thanks so much. Can everyone hear? I know this is a virtual appearance rather than a real one. I hope that works out all right. At first glance, it might actually seem odd that at a conference on reviving due process, the first paper really looks like it's about interring due process. That's not exactly right. I do not come to inter due process, but I do come to inter the due process of law clause of the Fifth Amendment. Not the 14th Amendment. That's a separate question. That's an epilogue to this paper that I'm not going to get into. Nor even the concept of due process as such, but the text of Fifth Amendment due process of law clause that I want to bury, at least for those interested in the Constitution's original meaning. The central point is that everything of consequence that can plausibly, or for that matter implausibly, be read into the Fifth Amendment's due process of law clause was already there in the Constitution of 1788. So that nothing of consequence is added to the Constitution by the Fifth Amendment, and therefore, if one is interested in the document's original meaning, there's not much point in trying to parse the language of the Fifth Amendment due process of law clause. And to explain what set me off on this odd notion, let me do a thought experiment. Imagine And let's situate this in the District of Columbia so that we can get away from any questions about Congress's legislative powers. Imagine that the President of the United States arrests someone, throws them in prison, seizes their property for wearing a brown hat on Thursday in public. There is no statute prohibiting it. There is no court judgment authorizing the imprisonment or seizure of goods. And just in case anyone's a fan of common law crimes, let's assume that there is no norm of general law that was violated. Okay, that's scenario number one. Scenario number two, the president says, well, why don't I get a judgment? And goes and gets a court judgment. And all of the proper procedures are followed for a court judgment, with one modest exception. The defendant is never given any notice of the action, and therefore never had an opportunity to appear and present a case. But there's now a judgment that the president can wave around. Third scenario, Congress actually enacts a statute outlawing wearing brown hats on Thursday in public in the District of Columbia. And the stated rationale for the law is that brown hats might attract poltergeists. Are any of the president's actions in any of those three scenarios, executing that statute, executing that judgment, the original arrest and seizure without either a statute or judgment, unconstitutional? Well, if we think in terms of modern notions of due process of law, at least two of those are easy cases, and the third is more interesting. One would say, what could due process of law mean in the executive context, other than the president can't go around arresting people and throwing them in prison without reference to some kind of law? Isn't that, after all, what the tradition, going all the way back to Magna Carta, is all about? What else would due process of law possibly mean? With respect to the court judgment, isn't it also the case that whatever arguments one can have about the content of due process of law, the requirement of notice for a valid judicial judgment is central? The first appearance of the term due process in an English statute in the 14th century was in connection with a requirement of notice and an opportunity to be. The third, the validity of the congressional statute, is a little trickier. I've situated things in the District of Columbia. We don't have to worry about Congress's enumerated powers. It uses its power under the District Clause. The question for modern law would be whether there is, in the notion of due process of law, some element of substantive rationality required for legislation, and people disagree about the contours of that. But that'd be the way the argument would be constructed. What I want to now do is set all of this on December 14th, 1791. Now, we can't look at the text of the Due Process of Law Clause, because there is no Due Process of Law Clause. It hasn't been ratified yet. That's still one day away. So if all we have to work with is the text of the Constitution of 1788, does anything change in constitutional analysis? And my argument is no. In fact, the only thing that changes, and this will be a bit surprising, coming from an old-fangled wooden originalist, the only thing that might change is it becomes clearer in 1788 than it might be today that there probably is a substantive rationality constraint on the legislature. And go through each of those three scenarios. What about the president's action in the absence of law? Well, all you've got is the 1788 Constitution, but where does the president get the authority to do anything? Well, of course, from the Constitution. Odd power here and there in Article 1, but it's essentially an Article 2 matter. What does the executive power that is vested in the president by the first sentence of Article 2 entail? And the short answer is, whatever questions there may be about the ultimate scope of that power, it is at heart a power to execute, to implement, meaning to carry into effect norms that already exist. Those norms can come from legislation, can come from exercises of judicial power, they can come from the general law, but they have to come from somewhere. Right? In 1788, just as on December 15, 1791, the president cannot simply make up a law and arrest someone on the basis of making it up. Nothing changes. The Fifth Amendment Due Process of Law Clause confirms and clarifies that basic fact, but it doesn't create it. It was there in 1788. The same thing is true with the requirement of notice for a valid exercise of judicial power. What do courts exercise? They exercise the judicial power of the United States. What is the judicial power of the United States? Well, you ask anybody in 1788 what judicial power is, they'll rattle off a set of things that courts have to do in order validly to exercise judicial power. And giving people notice and an opportunity to be heard, that's part of what it means to exercise the judicial power. You need to spell it out in a constitution, no more than it needed to be spelled out in the Judiciary Act of 1789, which simply contains references to pre-existing law of common law, of chancery, and so forth. Everybody knew what it meant to exercise the judicial power. But what about the enactment of statute? Right? This is really the subject of a separate paper, not the one that's posted on the website here, but one that was done separately. It's a chapter of a forthcoming book. The short version of that is that the Constitution is, in form and function, part of a category of legal instruments known to 18th century people as fiduciary. And as a result of that, there are certain background norms of interpretation that go along with that family of instruments. Just as if somebody appointed a factor to go to France and sell cannons, there would be a document, there would be certain background norms pertaining to that category of documents that would be part of the meaning of the document. Same thing is true with the Constitution. And as it happens, one of the most basic of all fiduciary norms is the duty of care. And the precise contours, what that entails in this context, as I said, that's the subject of a separate paper. Think of it as a business judgment kind of rule. But it does impose, as a matter of original meaning, some basic requirements of rationality, of care, on all federal actors, including Congress, in the exercise of all of its powers, including its power under the District Clause. So today we call substantive due process, and I don't like that term. I don't think it can actually be grounded in the text of the due process of law clauses, but something like that in function is actually quite easily derivable from the Constitution as a matter of original meaning. So the bottom line of all of that is that essentially all the content of 1788 is clarified, qualified in the Due Process Clause of 1791. But today, mostly use Due Process of Law Clause 4, mostly in connection with the administrative state, is to prescribe kinds of procedures that executive agents have to engage in order to act validly. What are the appropriate procedures for adjudicatory executive action? From a 1788 perspective, that's kind of beside the point. What 1788 is about is not how executive actors can act, it's what executive actors could do. The original meaning, if you will, of due process of law, not in the text of the Amendment, but in the interstices of the Constitution of 1788, is about substance, it's not about procedure. The modern emphasis on procedure is a result of a kind of reverse incorporation that feeds back a very, very different interpretative story about the 14th Amendment into the 5th Amendment. And I think that's actually a profound interpretative mistake. As far as the federal government is concerned, what matters is what people can do. If they can't do it, no set of procedures, however wonderful, however adjudicatory, however trial-like, can salvage something that is illegal because you can't do it. Right? So that's the short form of the argument. I've probably already taken more time than I was allotted, so I will stop at this point. The long form, about 60 pages worth, as Naomi said, is on the website. And I look forward to questions, comments, and conversation.
Well, I enjoyed Gary's talk, and I'm not going to disagree with much of what he said, but I do have a statutory authorization to begin with one anecdote. A couple of friends are going hunting. They're in West Virginia. They are West Virginians. Anyone here from West Virginia, you can object to the joke afterwards. And while they're out hunting, one of them grabs his chest, falls over, and apparently has died. His friend, of course, having a cell phone, pulls it out, calls 911, explains the situation, and says, "What do I do?" And the operator says, "Well, first, make sure he's dead." The operator then hears a gunshot and says, and the voice on the line says, "Okay, now what?" So there are two lessons here that are important for today. The first is, even the clearest and most easily understood instruction can be misconstrued. The second lesson is that there is an important difference between appearing to be dead and being dead. As Miracle Max said in The Princess Bride, mostly dead is still partly alive. And both of these lessons are important in law as they are in life. Due process in the beginning was an easily understood concept. It had three parts to it. One was the what part, one was the who part, one was the how part. The what part was depriving somebody of life, which meant being alive, liberty, which meant you weren't in jail, or property, which meant actual things that you own. The who part was, well, you had to be either a judge, a real judge, a properly appointed judge, or you had to be Parliament. Parliament had to make the rules, and then Congress had to make the rules. They set the law, and officials, government officials, just couldn't make it up. Somebody, the king or a consul, nobody could just go out and make up a law on his own or apply it on his own without an actual law in the background and an actual judgment. So that was pretty easy. Over time, as Gary said, things kind of wandered off in different directions, and notions like substantive due process, which means doing things I don't like, because I think you shouldn't be doing it, kind of mucked things up. And so did the softening of the actual process protections, to be, rather than doing things in a certain way that was understood to be legitimate, it was doing it kind of like that in ways that we think have enough of the protections. As Gary said, the core of due process were things like, if you had a court doing this, it had to include things like notice to the person involved. And as we have developed this sort of softened view of what due process entails, we've lost some of the core pieces. At the critical core of due process, before, and I'm taking this back now, before the Constitution was written, structure. If certain people have to do things in certain ways, structure is important. And the Constitution was all about structure. The reason why the Constitution and due process overlap so much is because the core concept the Constitution was built around is that certain people had to do certain things in certain ways. So Congress is given the power to write laws. If you're going to decide how you're going to affect people, Congress has to write a law. If you're going to apply it to somebody to actually do something significant, it has to be done through a court. And if what you're doing is not that significant, you're just applying what Congress told you, it can be done through the executive. We now have an executive branch which is a lot bigger, does a lot more things with a lot more people, to a lot more people than anybody ever envisioned. And you would think that the vesting clauses of the Constitution, the specification of who gets to do what to whom in the Constitution, would have something to say about that. But two of the developments that we've had, particularly over the last 75 years, have really thrown a monkey wrench into this. Judicial review is supposed to make sure that people stay within the bounds, that the structures are observed, that the constitutional provisions are adhered to. But the demise of the notion that there's a constraint on what Congress can give to others to do, the loss of the non-delegation doctrine, has allowed a lot of power to be given to agencies that was never thought of. We now have 10 to 25 times as many regulations written every year by agencies as we have laws passed by Congress. We have more adjudications by far and more adjudicators. We have about 4,800 adjudicators as administrative law judges or administrative judges in the federal government as we do federal judges. We have about 865 federal judges. Those of you in the audience who want to sign up, let me know later. We also, in addition to the non-delegation doctrine having been lost as a constraint on giving Congress's power to agencies, or the court's power to agencies, we've also lost the notion that the courts are really going to hold agencies accountable for staying within the bounds that they were given by law. The laws are bad enough, and we've lost the notion that we should constrain those. But we also have kind of softened the idea that courts will hold agencies responsible for staying within the bounds of the law. Chevron, which is the subject of, I think, 27 conferences a day in America, gives the impression that agencies are authorized to interpret the law themselves as long as they have a reasonable interpretation. It isn't what Chevron said, it isn't what the APA says, it isn't what ought to happen under the Constitution, but a lot of people have been misled into thinking that. What Chevron did say and ought to be read to say is what the APA says, which is that the courts tell you what the law is, the court tells you what the statute means, the court reads the regulations, and if the agency is given discretion under the statute, the court will allow it to operate within the bounds of that discretion. So what do we need now? Well, we need the courts to recognize that the instructions in the Constitution with respect to structure are important. And we need them to recognize and revive, to reduce the deference doctrine to what it is in the APA, and to revive the delegation doctrine, to look at it and say, it may be mostly dead, but it's partly alive, and to give it the resuscitation it deserves. And if we do those things, that will take most of the structure that is in the due process notion and give it life again. And I thank you for the opportunity and look forward to answering the complaints from people from West Virginia.
Thanks so much, Ron. Okay, and next we'll turn to Professor Woolman.
Hi, thank you for having me. I think particularly in Lawson's paper, I agree with Professor Klass and Professor Lawson that yes, there was a big structural component to the Fifth Amendment due process clause. Where I disagree with Lawson particularly is he claims that, well, and I also, I guess, agree that with Lawson that there wasn't much concern about procedures in the agencies under the old Fifth. Now, the reason there wasn't much concern under the structural version of the Fifth Amendment due process was if someone were, if the government were effecting an individualized deprivation of traditional life, liberty, or property, you could normally get full judicial process that would be de novo, for example, a trespass action against some officer who seized your property. In Lawson's paper, he also takes the position that really this old version of separation of powers, Fifth Amendment, was perfectly serviceable, and it was the 14th Amendment that sort of messed things up because it started to emphasize that it started to emphasize processes within the agencies due to the fact that the state and local governments were able to delegate power without the strictures of federal separation of powers. So I guess I wanted to take issue with the fact that it was the 14th Amendment that caused the focus of due process on agency, the 14th Amendment that caused this focus on agency procedures. I'm arguing that the focus on agency procedures would have been inevitable even without the extension of a due process clause to the states under the 14th Amendment. The reason I say this, well, there's two reasons I say this. One is that even under traditional Fifth Amendment due process, where you ordinarily got judicial procedures for a deprivation, or at least an individualized deprivation of life, liberty, or property, there were some gaps where there were deprivations of traditional life, liberty, or property where you didn't get any process. And those gaps would inevitably have led, I think, to people becoming, or the courts becoming, concerned with process within the agency. In addition, say it only requires a modest amount of delegation, even some deference on issues of fact, before the courts would become concerned with making sure that there were adequate procedures in the agencies. So let me go to my first point, that there were gaps in the old version of procedural due process under the Fifth Amendment, that is at the federal level, that it wasn't just a situation where you always got judicial process if there were a significant individualized deprivation of life, liberty, or property. A big gap there was in money owed to the government. And Lawson himself does note Murray's lessee, an antebellum case where the court did allow a distress warrant against a customs collector who had stolen quite a bit of money without judicial process. But he treats this as an instance of the courts examining under separation of powers in the Fifth Amendment deviations from traditional process for life, liberty, or property. But the distress warrant at issue in Murray's lessee was not a deviation from traditional process, but very much in line with it. That is, as the court in Murray's lessee points out, there was a long history of this kind of distress warrant without judicial process that ran against receivers of governmental money. The federal government had statutes allowing this kind of procedure from the 1790s. Lest you think it's just people who perhaps waived their rights by being governmental employees or officers. That wasn't the case. It was also people who paid taxes who were subject to tax collection was also considered an area where judicial process was not required. And you see this in action in the federal government in the area of customs collection. That is, for quite a long time, the courts said that the valuation of goods by appraisers, government appraisers for purposes of customs, was final, and the courts wouldn't reconsider that finality. So my point is this, that even without the extension of due process through the 14th to the states, there were these gaps in process, even under old Fifth Amendment due process, that ultimately would have suggested that it would, to the courts, that they should extend procedures into the agencies. Now, my second point is related to the first one, and that is that it doesn't require much delegation in order for the courts to become concerned with process in the agencies. That is, even if you have a relatively modest delegation with some deference on facts and even full review of law, the courts are going to become concerned with what the procedures are in the agency. For example, in those customs cases, once the court started saying we're going to give finality to these determinations of value by these appraisers, well, litigants started to raise problems with the procedures by which the appraisals occurred, and those got court attention. And you can see in any number of areas, for example, I mean, this is somewhat later, but in the ICC area, once they got rate-making power, and once the court started to defer to their factual findings, the court started to really discuss procedures before the ICC. Now, Lawson does treat the 14th Amendment as getting out there. And we'll all agree that there were more 14th Amendment cases arising in the late 19th century than Fifth Amendment cases. But I would say the 14th Amendment really, the Fifth was pretty much up there with the 14th. The 14th wasn't that far ahead in terms of being concerned with agency process. Because after all, you had some delegations, started to have some broad delegations in the states, but they followed pretty soon after in the federal government as well. And for example, there was at the time of Londoner versus Denver, which is considered one of the big procedural due process cases, 1908, where the court required some process as to tax collection for the city of Denver within the agency. It was 1908. Roughly simultaneously, you see in immigration cases, the court saying that the agency has to provide some process, for example, for someone making a colorable claim of citizenship who's excluded at the border. So, in conclusion, I would say, well, the old version of separation of power, the Fifth Amendment version of separation of powers, had some gaps in it where people were deprived, particularly of property, and no judicial process was required. And I think it's fairly inevitable that those kinds of situations might be remedied eventually by requiring process within the agencies under the Fifth Amendment. And also that even without the kind of broad delegations that we have in the modern world, even a modest delegation where the courts defer to some extent to the facts found by the agency is going to put pressure, is going to lead to the courts requiring that the procedures within the agency be adequate.
Thank you very much. Next we have Nelson Lund.
Chief Justice Roberts recently warned about a real danger that the partisan confirmation battles over Garland and Gorsuch would cause the public to think that the judges themselves are partisans. On the contrary, he stressed, the court quietly goes about the business of deciding cases according to the Constitution in a completely nonpartisan way. Now, I think there are two different ways to respond to these comments. One might smile indulgently, recognizing that the Chief Justice believes he has an obligation to defend his court's reputation, just as Sean Spicer seeks to defend the integrity, the competence, and the truthfulness of the president. A more cynical response to the Chief Justice's comments would be to laugh out loud. Should we really be nostalgic for the time when Republican appointees were generally indistinguishable from those appointed by Democratic presidents? That's what gave us William Brennan, Earl Warren, Harry Blackmun, Lewis Powell, John Paul Stevens, and David Souter, among others. Except for John F. Kennedy, no Democratic president during my lifetime has appointed a justice who deviated in any significant way from the political agenda of the progressive left. Now, why do we have partisan battles in the Senate? The reason is simple. Because Republican presidents have tried to appoint judges who would actually be committed to deciding cases according to the Constitution, as Chief Justice Roberts put it. That effort by Republican presidents led to the disgusting spectacles of the Robert Bork and Clarence Thomas hearings and to the partisan filibuster against Sam Alito. That filibuster was supported by 25 Democrats, including Barack Obama, Hillary Clinton, Joe Biden, and John Kerry, so it was not a fringe phenomenon. The partisan filibuster against Neil Gorsuch, which was supported by all but 4 Senate Democrats, was only the latest stage in a decades-long crusade against the kind of originalist analysis that Gary Lawson and Ron Cass have brought to bear on the due process of law clauses. There's a striking difference between these papers and the Supreme Court's substantive due process decisions. And I don't just mean that the papers arrive at different conclusions than the court did. The most significant difference lies in the quality of the research, the rigor of the reasoning, and the seriousness with which both authors take the Constitution. Can we hope that scholarship like this will help the court to do better than it has in the past? I doubt it, and I'll briefly explain why I'm pessimistic. Let's start with the first great substantive due process decision, Dred Scott. Chief Justice Taney's opinion for the court struck down a statute that outlawed slavery in the Northern Territories. Taney's entire legal analysis is contained in the following ejaculation. An act of Congress which deprives a citizen of the United States of his liberty or property merely because he came himself or brought his property into a particular territory of the United States and who had committed no offense against the laws could hardly be dignified with the name of due process of law. Now, Dred Scott's owner obviously did commit an offense against the laws by holding him in slavery at a place where slavery had been made illegal. Taney gave no argument for declaring the statute unconstitutional, and he responded to Justice Curtis's well-reasoned legal objections with dead silence. It seems that Taney neither had nor needed legal arguments to support his conclusion. Rather like the bandits in The Treasure of the Sierra Madre, Taney's position was that when you got the votes, you don't need no stinking reasons. Undeterred by the ensuing Civil War, the court continued to think it had discovered the philosopher's stone in the Due Process Clause. Striking down a statute that made paper money legal tender in 1870, the court's reasoning was Taney-esque in its simple grandeur. It is quite clear, said the court, that whatever may be the operation of a statute that directly diminished the value of existing contracts, due process of law makes no part of it. Now, that decision was quickly overruled, but the justices never paused very long before returning to Mount Olympus and hurling due process like a textual thunderbolt at statutes that offended them. Never in the court's history has anyone produced evidence that either of the Constitution's due process clauses contains a secret message telling judges that no person shall be deprived of life, liberty, or property unless judges find the deprivations sufficiently inoffensive to their moral and political sensibilities. Not during the so-called Lochner era, and not during the current epoch, which began with Griswold versus Connecticut. Instead, we've been subjected to a series of opinions that have become increasingly entertaining. Entertaining, that is, if you have a taste for the humor of Don Rickles. Take Griswold, for example, with its famous emanations and penumbras. The argument, such as it is, seems to be that since there are constitutional provisions that protect specific kinds of privacy, like the Third and Fourth Amendments, there must be a general right to forms of privacy that have nothing to do with anything mentioned in the Bill of Rights. Now, that's obviously an insult to the intelligence of the reader. Apart from the obvious expressio unius problem, one could just as logically say that since the Bill of Rights protects some actions, it therefore protects any action that a court chooses to place in the infinitely expandable penumbras of the Constitution. The court soon found a right to abortion gestating in those fecund penumbras. Roe v. Wade was typical of previous substantive due process cases in carrying out what Justice White called an exercise of raw judicial power. But the court's opinion was particularly droll in its treatment of the Constitution's text. Justice Blackmun stressed that the right to privacy might be in the 14th Amendment, or it might be in the 9th Amendment. Where it came from didn't really matter, because the court was sure that a right to abortion had to be in there somewhere. The court's increasingly ludicrous and insulting judicial rhetoric eventually culminated in a series of opinions by Justice Kennedy. Who can forget his creation ex nihilo of the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life? Ergo, the right to abortion must be reaffirmed. Or the court's reification of liberty, which supposedly extends beyond spatial bounds and presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. Ergo, a right to sodomy. Chief Justice Roberts has reassured the public that the court has been quietly going about the business of deciding cases according to the Constitution. What did he mean when he said according to the Constitution? I don't suppose he could have been referring to his court's latest substantive due process decision, which created a right to same-sex marriage. In his dissenting opinion in that case, Chief Justice Roberts himself had this to say: "The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent. The majority expressly disclaims judicial caution and omits even a pretense of humility, openly relying on its desire to remake society according to its own new insight into the nature of injustice." Just who do we think we are? Now, the problem identified by Chief Justice Roberts here could, in theory, be solved if 5 originalist judges were appointed to the court. But how likely is that? Consider the following anecdote. In McDonald v. City of Chicago, the court was asked to apply the Second Amendment to the states. The obvious way to do so was through the substantive due process doctrine known as selective incorporation. Surprisingly, however, the lawyer for those challenging Chicago's handgun ban asked the court to use the Privileges or Immunities Clause instead. Now, from an originalist perspective, that was a perfectly plausible suggestion, and Justice Thomas adopted it in his concurring opinion. At oral argument, however, the lawyer who advanced the argument was mocked by Justice Scalia for pressing an argument that Scalia called the darling of the professoriate. Scalia even suggested that the lawyer was bucking for a place on some law school faculty. Now, that's just about the most insulting thing you can say to an advocate. For it basically means the fellow isn't a real lawyer at all. He's probably some navel gazer who wants to write about the influence of Immanuel Kant on evidentiary approaches in 18th century Bulgaria, as Chief Justice Roberts so memorably put it. And why exactly should the hapless lawyer have relied on substantive due process to incorporate the Second Amendment? Because Scalia himself had acquiesced in that doctrine, even though he thought it was wrong. According to Justice Scalia, then, originalism is the only proper approach to constitutional interpretation, except when he had rejected it, at which point it became an exercise in academic silliness. Now, that's obviously a corollary of his oft-stated claim that he was an originalist, not a nut. That attitude, expressed by the court's most rhetorically aggressive crusader for originalism, suggests that the future is going to look a lot like the past. I learned more about the due process clauses from these papers than I've learned from all the opinions of the court that I've ever read. That's a tribute to the authors and an indictment of the court. On the bright side, however, our imperial court does wear an amusing suit of clothes. Thank you.
Thanks, Nelson. Okay, so we're going to have a little bit of a discussion then between the panelists, and then we will open it up to your questions. So maybe, I guess I have a question for Ron and for Gary based on what Nelson was saying. So I also enjoy the papers very much, and I'm wondering, what do you think it would look like for the court to think about due process in the terms that you've outlined in your papers, and are you as pessimistic as Nelson that could happen?
Well, first of all, it's hard to be as pessimistic as Nelson.
Well,
He works hard at this. He's got a lot of experience at it. I come from a family of worriers, so I worry a lot, but I tend to be optimistic. I think that for all the worrying, things can really get worse, and that if I worry just a little bit more, they might, but I'm not certain of it. I do think that there are reasons to think that bits and pieces of the law will come back in the right direction, although not necessarily under the heading of due process. And what Gary was saying, and what I believe, is that the words due process before the Constitution meant something that was largely implemented through clauses in the Constitution. And if we can get those clauses to be interpreted as they should be, that will do an awful lot of the work it should. So from my standpoint, things like the delegation doctrine, I don't think will come back in full force. But two of the justices, actually three of the justices on the court now, have expressed support for a pretty full-blown delegation doctrine. Some of the justices have agreed with opinions that look at structure seriously and would cut back on other things. And I think those can come together to limit some of the sort of broad delegations we have. That'll do a lot for due process. The deference doctrine, I think, is changing. I don't know how it will change, but I would not be surprised to see the Auer doctrine abandoned and Chevron reconfigured. So I think that would be good. And if these things happen, I think that will do for the federal government a lot of what a real due process clause would. And then we have to ask whether it would apply to the states the same way.
Mattering?
I thought in reading the papers that both of them suggested the rolling back of deference, Chevron and our deference, and that would probably be the easier way to, or more likely way that any of this might be implemented rather than too much reinvigoration of a non-delegation doctrine. I know it's related to non-delegation.
Okay. Well, we'll open it up to some questions from the audience. You have some questions?
And by the way, with law professors up here, if you don't ask us questions,
Yeah.
we'll ask you questions.
Right. No? Questions? Okay. Yes.
Is there, when folks talk about substantive due process being kind of a brand new thing within the Constitution, within how people interpret the due process clause, I'm curious as to whether or not anyone up there believes a reasonable interpretation of other portions of the Constitution are supposed to embody what people sometimes refer to as. Can you hear me? Well, I don't know. I wonder if you guys think it's a reasonable interpretation to think that other portions of the Constitution embody what is sometimes thought to be embodied in the Fifth Amendment's due process clause under substantive due process. And what I mean is, would you argue that you find it reasonable to believe that either the Ninth Amendment or Article 4's Privileges and Immunities Clause is supposed to offer some kind of substantive protection that prevents either the legislature or administrative agencies from passing certain kinds of laws?
Well, first of all, substantive due process, just to say it, if you said procedural due substance, that's a term people aren't used to hearing. They would say, what the heck does that mean? It seems meaningless. It's like, milk, coffee, tea. Those are three different things. They don't go into one thing. Substantive due process is equally meaningless. It means that there's something that I don't like substantively, and I'm going to call it a due process violation, even though there's no reason. It has nothing to do with process whatsoever. There are things in the Constitution that limit what the federal government can do. the whole, if you look at the Constitution and you see it on one piece of parchment, one of the things you realize is that Article 1 of the Constitution, which deals with Congress, lawmaking, and what the government can do, is huge. And then as you go through the rest of the Constitution, it's like one of those things where it says plan ahead, and you see the little thing get squeezed down to nothing at the end. The rest of the Constitution really wasn't thought to matter nearly as much as limiting the power of Congress, since Congress was the starting point for exercising the power of government. So yes, there are substantive limits. The courts have abandoned the real substantive limits in the Constitution and substituted other limits more congenial to their view of good government. And that's a fundamental problem with interpreting and applying the Constitution.
Do we have Gary back? Or?
Gary? Nope.
No. Okay.
Gary? Nope. I'm sorry, everyone.
Okay.
I think it's the connection. I don't know what happened. We can't hear you, Gary. I'm sorry.
Yes, we have a question back here.
You all, several of you made the suggestion that perhaps non-delegation could be brought back a little bit. And I wondered whether you worry that that kind of little bit of non-delegation in the courts will introduce the very subjective judicial rulings that you criticize. So for example, I'll just give you an example of what I see the court doing today that has that kind of selective introduction of judicial subjectivity, which is in recent cases the court has declined to give deference under Chevron to agency decisions that it views as irrational or too big, in a way, too important for an agency to make. And I see these cases as simply skewing in an asymmetrical fashion against aggressive or ambitious regulatory programs and toward more timid regulatory programs. So to me, that introduction of a little bit of the kind of constraint that you're suggesting is simply an expression of the judge's own subjective preferences for a particular kind of regulatory state. So I wonder whether the little bit of non-delegation would actually deepen that kind of judicial subjectivity.
Well, I don't think it's similar at all. And let me take this in two bites. First, when you talk about the major questions doctrine and that view of Chevron, if you look at something like the tobacco case, where the FDA asserted that it had authority to regulate tobacco use as a drug delivery device delivering the drug nicotine, after decade after decade after decade of saying that wasn't what the law meant, and no one at the time the law was passed thinking that was what the law meant, and no evidence that anyone at the time understood the law to be that. Had the law been understood to give the FDA power to regulate tobacco, it's quite clear that there would have been something of an uproar at the time. And certainly tobacco at the time that the Food, Drug, and Cosmetic Act was passed was a very commonly used object. And it was something that the tobacco industry certainly would not have easily gone along with giving the federal government and the agency, the FDA, power to regulate. So I think when Justice Scalia in the next case said that you don't hide elephants in mouse holes, we don't want to interpret a law to mean something that nobody thought it meant, nobody understood it to mean, and we now have discovered that. I think that's a perfectly sensible canon of statutory construction. I think also when you look at cases like UARG, for the court to say that for the EPA to rewrite the law and to say we're going to have to tailor this because the limits in the law wouldn't make any sense with our interpretation now, So we're going to rewrite the law. We're going to raise the limits 750 times for one class of pollutants, 400 times for another class of pollutants, because otherwise the law won't work right. That's a blatant rewriting of the law. I don't see anything in the way the court has been applying the Chevron to major changes in the law to be at odds with a straightforward application of its job to interpret the statute. The other part of your question, which deals with wouldn't bringing non-delegation back reintroduce essentially substantive due process? I don't think so. You look at the sort of delegations we had when the government was young. They gave out authority to administrative officers to do a lot of different things, but not to make fundamental decisions on the law, not to make decisions of major importance. And I think the question, is this of major importance? Is this the sort of question that is properly lodged with executive officials? Is a different question than, do I like it substantively or not? And I think it's certainly the question that John Marshall asked back in the 1820s when he was looking at this. I think it can be asked and would be asked in a less manipulative way than substantive due process has begun. But that I hope we will see, and we can have another conference on who was right and wrong on that.
Nelson, did you want to weigh in? Do we have Gary, are you back?
One more try.
There he is.
I'm in?
You're in. Oh, sorry. Did you want to respond to any of the comments from the panel originally, or Nelson's comments?
Yeah, that's the wrong one.
Oh,
Yeah, I was going to go back a little bit, so I'll catch up on a bunch of things here. I would normally view Nelson's view of courts as too optimistic. Much worse than he thinks they are. The only thing I will say about that is come back and ask me in 3.5 years. Because what I will know then is, has there been a change fundamentally in the composition of the court? That is, are we seeing more Sandra Day O'Connors, John Paul Stevensons, and David Souters? Are we seeing 2 or 3 more Gorsuches, whose greatest virtue as justice is that as a lower court judge, he cited meat lot on non-delegation. So you get a whole bunch more of those floating around, and we'll also know in 3.5 years who the next president is. And that would be valuable information. If the courts look now, no, this is why I retreat into the academy and write about abstract jurisprudence and 18th century stuff rather than current law, because it's too depressing to do. The only other thing I wanted to say was, I've said construed as kind words about substantive due process. Not really, but it can be construed that way. Let me say about that. I don't think the term is oxymoron, because that is the words of law. It's due process law, not due process. Not being oxymoron doesn't, it makes sense. I actually don't think it does. What I do think makes sense is one of the things that is baked into the Constitution of 1788 as a limitation on the powers of Congress and the other institutions of the government is this fundamental fiduciary duty of fair notion. That bears a family resemblance to substantive due process. It's not grounded in what people think is a good idea at the time. It's grounded in 18th century fiduciary law, which, for those who haven't looked at 18th century fiduciary law, does not bear a very close resemblance to the political platform, the liberal wing of the Democrat Party. Just doesn't. But that argument, even that far, only extends to the national government. Dozens of states are not fiduciaries under the Constitution, except in limited circumstances. So anything you want to say about rationality of state legislation, that would have to be grounded in a dignified, honest-to-goodness, substantive due process argument. And while I don't think that is as laughable as Nelson thinks it is, I do think it is titterable or chuckleable. Not going to happen. So I could catch up on a whole bunch of other things too. I did want to say that I agree with almost everything that Professor Wolfhandler said in criticism of my article. At the roundtable, big discussion topic was whether the whole section on the 14th Amendment should be dropped. So yeah, I agreed almost everything that she said in criticism of that argument. All right, now I'm back in.
Okay. Thanks, Gary. Glad you're back. Question here? Yes.
Yeah, so there was a decision in the Ninth Circuit upholding an injunction that you might have read about that had some interesting things to say about due process that it seemed to maybe not have remembered Londoner and bimetallic. And the way I read it at first, I thought it was overturning, this huge portion of every state law across the country because there's all these different things where you don't get notice and opportunity to be heard in front of state agencies. But if you're saying there's a difference between the 14th and the 5th Amendment, then I start to get interested in what the Ninth Circuit was saying. Is there a way to say that the 5th Amendment due process limitation looks a lot more like, hey, you can't do legislative rulemaking, federal government, and we'll have a different requirement that's more lenient under the 14th? Is there room for doing that?
Not under current doctrine, there isn't. There's certainly a theoretical case for it. There's a very, very strong theoretical case for it. I mean, I actually think the 14th Amendment adds something to the Constitution while the 5th Amendment doesn't. So I'm very sympathetic to the idea that there's a difference between the two. But pretty much across the board in the whole post-incorporation age, the court has never shown much sympathy for the idea of differentially applying constitutional provisions once it says that they apply to both. And certainly the process under the due process clauses has always been a lockstep one. But I don't think there's anything in the nature of interpretation that dictates that. And I'd be very happy to see someone reconsider it.
Yeah, I suppose I just have trouble seeing a big divergence in 14th and 5th Amendment procedural process myself. Maybe I'm just too much of a product of the modern era.
Questions?
There it is. We're governed by politicians.
That was just the NSA turning that off.
In 1791, we were governed by politicians. Politicians come up with concrete directions on delegating their authority, such as all rates shall be just and reasonable, or contracts in restraint of trade shall be illegal. With political direction like that, how can you give delegation back to Congress?
Well, in fact, there are very easy ways of distinguishing some of the types of directions that are given on small matters from directions that are given on larger ones. So, for instance, if you go back to, you were talking about 1791, 1789, 90, 91, there were a series of acts that gave authority for executive or administrative actions. And a lot of them were fairly vague about exactly what the terms were going to be of the action, but they were all fairly small. So let me take the Residency Act, for instance, which deals with the District of Columbia. The Constitution says you can create a district for the federal government. They can be taken from different states. There was a real fight over where it was going to be. And this was a huge political issue where this was going to be located. Congress in the Residency Act said where it was going to be located. But it didn't precisely, well, it just said, okay, right around here. Then it gave to a commission the authority to actually figure out which piece of land it would be and what buildings would be needed for the federal government. And it gave almost no direction at all. But it wasn't an important issue. The same thing, the Judiciary Act gives the judges the authority to adopt certain procedures. So courts regulate what happens in the court. It didn't specify things with great detail. It did specify a lot about what subject matters the courts could address and which courts would address which one and how they'd be constituted. But the things it left open weren't very important. So we have this notion that comes from Taft's opinion in the J.W. Hampton case, that the precision of the instruction is what matters. It really isn't. It's not the precision of the instruction. It's the fact that Congress decides the important issues and leaves the administration of them to the government. And if it's administering things like land management, benefits administration, doing things that are within its domain and not within the domain of the legislature, we don't care that Congress isn't very precise. But if Congress is giving out authority to do things that it should do, then we should care. And that's what the non-delegation doctrine should be about. Now, if you're saying we have a long time of Congress not doing that, you're absolutely right. We do. But that doesn't mean that we can't bring back some notion that Congress has to make fundamental decisions itself, particularly fundamental decisions that govern private spheres of activity that formerly were thought to be things that you needed a law to regulate.
I would just add that some of the somewhat earlier delegations that look broad, well, let's say just and reasonable rates, weren't as broad as they look because just and reasonable rates had a meaning. That is, cost of service rate making that gave a fair return on the current value of the property devoted to the public service. At least that's what it meant for, under Smith versus James. And so some of these areas actually had more meaning. Of course, Congress does give out broad delegations. I suppose, at least in the important areas, if the court made them be more specific, one could have, well, maybe this is too sanguine a view, one could have this vision where people have to work harder in Congress on actual legislation, and that more nerdy types are attracted to being congressmen, and they don't go home every weekend, and they actually do, sit and pay attention to what is in the legislation.
Let me just add this. Everything that you've just heard is absolutely 100% correct. Here's the only thing I will add to it. The proposition that there is a constitutional limit on what Congress can grant to other actors is one of the most overdetermined propositions of constitutional law. There are a half a dozen different modes of analysis that will all lead to exactly that place. Once you're there, the question then becomes, okay, when is it that Congress is vesting in other actors like the executive or the judiciary, things those actors aren't supposed to do? That's the default question. Ron Cass is absolutely right that it can't be answered just by looking at the precision of the statute, because how precise the statute has to be is a function of what the character of the issue is that the statute is addressing. The question is whether the executive actor is exercising executive power, the judicial actor is exercising the judicial power, or whether they're exercising something better called legislative power, which is vested only in Congress. And that's not something you can answer in the abstract. Because it doesn't have an abstract, root-like answer, my old boss, Justice Scalia, who advocated this as an academic, refused to enforce it as a judge. Just decided it was effectively non-justiciable. That was a profound mistake, and I think Justice Gorsuch is going to be a large improvement in that regard. It requires an element of judgment, but that's why judges are called judges, and that's why they get paid.
And I guess I would also say that, non-delegation is not just a principle for courts, right? It's a principle that applies to Congress, sort of irrespective of whether courts are vigorously enforcing it, right? It's a non-delegation principle. It's not just a judicial doctrine.
Yeah. I'd love to see the president veto some bills on the ground that they unconstitutionally delegate authority.
I will say, Naomi, that Ed Levy, one of his favorite comments was it was far better for the legislature to act judiciously than for the judiciary to act legislatively.
Yeah. Okay, I think we have time for one more question. So,
occasionally, Congress and state legislatures vest government power in private parties. There were a series of cases early in the 20th century that dealt with the constitutionality of that. The Eubank case dealt with a delegation by the city of Richmond. The Carter-Cole case dealt with a delegation by Congress. Now, even if you look at the Carter-Cole case as an appointments clause matter rather than a delegation matter, you can't look at the Eubank case that way because it came from the states and the appointments clause doesn't apply to them. What is the likelihood the Supreme Court will put restraints on how much government authority that Congress and the states can delegate to purely private parties? It's a structural type of limitation rather than a proximate cause limitation on things that go too far. But what's the likelihood they'll actually do that?
Likelihood that the court will do that? Modest. I mean, conceptually, those are different questions. The question with the federal government is a non-delegation question. The question with state governments is a Republican form of government question. And those are two different analytical issues. Whether either of those is likely to be revived by the courts in the near future, I would be highly skeptical.
okay. Well, I think we're pretty much out of time. We'll have a 15-minute break, and then we'll start the second panel. Thank you. Thank you.